Open work permits for family members of foreign workers who can apply. I have a client who actually applied an open work permit for her spouse. Now, ang sabi dito, this person is a caregiver program under the in-home caregiver program, of course. And then yung asawa niya is from the Philippines, and in-apply niya yung asawa niya coming here as a open work permit. Kasi ang sabi dun sa website, open work permits for family members of foreign workers, they can apply. That's what they said. Now, babasahin ko lang yung result. Ang sabi dito, eligible, thank you for your interest in working in Canada. After careful review of your work permit application and supporting documentation under the International Mobility Program, I have determined that your application does not meet the requirements of the Immigration and Refugee Protection Act, IRPA, and Immigration and Refugee Protections Regulations, which is IRPR. Ang sabi ng officer, I am refusing your application on the following grounds. Eligibility for a work permit in this category only applies to the spouse or common law partner of a work permit holder who is doing work that is at a level that falls within National Occupation Classification or NOC skill level 0, A, or B. You are not eligible for an open work permit. Yun ang sabi sa asawa. The work permit of the principal foreign national was issued under an LMIA in the lowest stream. Now I'm going back to the website. Ang sabi na naman dito, open work permit for family members of foreign workers who can apply. So if you read it word by word, it's so obvious that the result of this is wrong. Well, I need to explain. I am telling you the officer is correct. Now, I'm going to show you this. Your family member may be eligible for an open work permit under this temporary measure if you are a foreign worker in Canada who is in any of the following. Number 1, high-skilled worker, principal foreign workers requirement, of course, andun na yung, you have a valid work permit, mayroong exemption apply, an approval for a work permit that hasn't been issued, an authorization to work without a work permit. May mga ganong options. Your work permit or authorized work must be valid for at least 6 months for before your family members apply for open work permit. You are employed or will be employed in a high-skilled occupation, training, education, experience, and responsibilities tier 0, 1, 2, 3 of the NSO or NOC at the time your family member submits their application. You're living in Canada or plan to live while working. Now, there's an exception. Your family members are not eligible for temporary measure if any of the following situations apply to you. Ito yung sinasabi sa principal foreign worker. You've made a refugee claim, you're subject to an unforeseeable removal order, you're an international student who's working in a co-op program, you're an international student working off campus without a work permit, you're applying for a post-graduation work permit or PGWP but have not received a positive decision on your application at the time the decision of your family member's application is made. You hold a spousal open work permit. So, yun yung mga exception para hindi ka maging eligible. Now, eto na naman, ang family member requirements. Your family member must have 3 requirements. They meet the general eligibility requirements. They are in a genuine relationship, dependent child of your spouse. If your family is in Canada, they must be in one of the following situations. They have valid work temporary resident status. They applied to extend their status before it expired. They are eligible for restoration for visitor, worker, or student. So, ibig sabihin, maintain your status if you are here in Canada. Now, ang question, pinaka-main thing is that low-skilled worker. Pero bakit sinabi dito na low-skilled worker is possible for the spouses or family back in the in their home country para makapag-apply ng open permit. Kasi ang sabi dito, as is, sabi dito, you must meet 4 requirements. You have one of the following: 1, a valid work permit; 2, an approval for an work permit that has not been issued yet. Ibig sabihin, na-approve na. Like for example, passport request na siya pero hindi pa na-issue, and or maybe sinabing qualified ka or pwede kang makakuha ng work permit. So kumbaga approval in principle ang tawag doon. An authorization to work without work permit, usually yung mga seasonal yun, seasonal work. So number 2, kailangan 4 eh. So, number 2, your work permit must be valid in Canada for at least 6 months after we receive your family members' open work permit application. You are employed or will be employed in a low-skilled occupation. Low-skilled occupation. Ang sabi doon, training, education, experience, and responsibilities category 4 or 5 of the National Occupation Classification System. At the time your family member submits their application, I will definitely come back there and clarify that. And you're living or plan to live in Canada while working. Ang daming exemption, ang daming nakatago na reason. Kaya nga, ulit-ulitin mo man. So ngayon, eto na. Okay? Eto na yung sinasabing who is not eligible at this time. Yung sinabi nilang low-skilled worker na you are employed or will be employed in a low-skilled occupation. Pero, ang sabi dito, okay, when the ESDC or Employment Service Development Canada issued and assessed that LMIA from that employer, and yes, andun na yung caregiver program, andun yung low-skilled worker. The problem is, ang inilagay dun, kasi may 2 option yan eh. You can have a low-skilled worker na caregiver at high-skilled worker, which is, ang ibibigay na sahod sa'yo is hindi sa median rate, hindi rin sa minimum rate, but it is in the high-wage category. So, kung yung employer mo nagbigay siya ng high wage category, regardless kung nandun man yung sinasabi na tier 0, something like that, like tier category 4 or 5, tapos ang binigay or inoffer na salary dun sa contract is only median, then hindi qualified yung inyong spouse. Dapat ang sahod is nasa high wage siya. So, ibig sabihin, hindi sa minimum, hindi sa median, but nasa high wage at the time that your employer and the ESDC or Employment Service Development Canada were actually assessing your application. However, I wanted to clarify this so much a lot of times kasi ang dami-dami pong naguguluhiminan, something like that, I don't know, I'm sorry. But yun yung nagiging confusion right now. Sabi doon, low-skilled worker. Ano nga ba yung reason bakit na-refuse like this? Ang gulo, di ba? In terms of immigration law, you have to read between the lines. Okay, so yun yung reason kung bakit nare-refuse yung mga caregivers. Make sure when you ask for an application sa inyong pamilya right now, yun ang sabi, which is nandito sa pilot, I'm talking in Tagalog. I hope na intindihan nyo. Ang pinaka-importante kasi ang dami pong caregiver dito sa Canada that they want to bring their family. Ang sabi doon, you are employed or will be employed in a low-skilled occupation. Responsibilities tier category 4 or 5. The thing is, babalik sila doon sa pag-assess. Immigration will go back to the assessment ng ESDC at saka yung employer kung ano yung binigay at inoffer na sahod doon. Kasi may category yan. Median rate or high wage or sa low wage. Okay? So, I hope naintindihan nyo na. And again, this is just my explanation from the immigration. If in case you're going to apply, do not quote me in this situation. Please do your due diligence. Kayo pa rin kasi immigration keeps on changing. It is not my responsibility. This is just my opinion and my advice to everyone. I hope naintindihan nyo po ang aking ibig sabihin. Now, if you have some follow-up question, please feel free to connect with me and seek a consultation. Have a great night, everyone. This is Narlyn Oligo Sarma.